Oh, hey folks, elder law care attorney Patrick Kelleher coming to you from elderlawcare.com. Hey folks, today we got a great question from another subscriber. Hey Patrick, what should we do when we're retiring? What are the big estate planning steps? And I broke it down into five. So stay tuned, get your pen out, your notebook, folks. I'm going to give you five tips, five important tips that you need to undertake when you're retiring. All right, let's get right to it, folks. Number one, you need to create your estate plan, folks, or if you have one, you need to have it reviewed and oftentimes updated because a lot of folks are walking around with will, and a will is your admission ticket to probate court and the false sense of security. A will is not going to protect your stuff and your hard-earned assets from the metaphorical four-headed monster. A will is not going to keep your affairs out of probate. A will is not going to give you tax planning. A will typically is not going to give you asset protection for your spouse and your kids. And a will certainly not going to protect your home from the $15,000 or $18,000 per month nursing home. So most folks will need a trust. They'll need a trust that's drafted properly. A comprehensive trust-centered plan, from my experience, is the best way to protect, so long as the T's are crossed and the I's are dotted, okay? But a big portion of that, you have to make sure that step one, creating that trust, it's not a magic red book, we often say. You have to engage in step two, which is trust funding. Getting your treasures properly retitled to your trust, folks. You have to retitle your treasures, your house, your non-real estate, get it in there, but work with an experienced elder law attorney. This is not a substitute for legal advice. Trust funding is one of the most critical steps to a successful estate plan. You don't want to be walking around with a trust that's unfunded, that's like an empty treasure chest. You got to get your treasures in there, folks. Number two, review all your beneficiary designations. Review your beneficiary designations on your qualified retirement accounts, your IRA, your 401k, whatever type of qualified retirement account you may have. Even your bank accounts, investment accounts, life insurance, things of that nature. Sometimes you'll be surprised who the beneficiary is or are. It may be not people that you want it to be. Could be sometimes former spouses, could be sometimes nobody, it could be your parents who are not even with us any longer. Update those beneficiary designations. And then that's part of trust funding. Step two, work with a qualified, experienced elder law attorney to make sure you're crossing the T's and dotting the I's, and naming those beneficiaries the proper way, especially if you have a trust, okay? Can a trust be a beneficiary? Yes, so long as it's structured properly, as long as the language is proper in the trust, and the trust is a qualified trust. There's certain legal requirements that go along with that, hence the reason why you need to work with an experienced elder law attorney who's familiar and experienced in this field. The takeaway, do not do it on your own. Do it with an experienced estate elder law attorney. Step three, keep an eye on your trust or your treasure chest as you journey through life, because the three L's, there will be law changes. How much control do you have over that? None. There will be life changes in your health or with your health, finances, and relationships. How much control do we have over that? Sometimes not a lot. But let's move on here. We've got a few more. Number three, review your Social Security options. If you're 62, you've reached the magic typical age of Social Security distributions where you can receive Social Security so long as you have 40 quarters and so forth, okay? Meaning that you worked at least 10 years full-time typically to receive those 40 quarters under the Social Security rules. 62 typically is the first time you can start receiving Social Security benefits, but you can work with your elder law attorney, run the numbers, your financial person as well, run the numbers, or a Social Security expert. And if you defer it until age 70, it typically goes up around 8% per year. So it can be pretty substantial if you defer it until age 70. So that's typically the recommendation. If you can defer it and not take it at 62, not take Social Security at 62, so long as you have other sources of income coming in, your spouse could be still working a full-time job, you might have a retirement account or a pension or something like that, or a rental income or whatever it may be. But if you can defer it until 70, financially, economically, you'll be better off. So again, it's different for everyone. So run the numbers, meet with your qualified professional, assess and evaluate what is best for your situation. Number four, review your qualified retirement accounts. Under the Secure Act, you do not have to start taking those required minimum distributions called RMDs, required minimum distributions, now till age 73. So in a perfect scenario, if you have other sources of income stream coming in, or if you have a younger, healthier spouse that's still working and they're pulling in full income or revenue per year, if you do not need to touch your qualified retirement account, such as your IRA, 401k, Roth, etc., You can allow that money to continue to grow tax deferred until age 73. And then once you start taking the money out at 73, you're typically a financial company will tell you and share with you in a letter how much you have to take out each and every year. Usually it's a percentage of the gross amount. And then that money comes out, whatever that money is, if it's 10,000 or 30,000, that'll get added on to your 1040 income tax return, and it might put you in a higher tax bracket depending on what other income sources you may have coming in. Number 5, health insurance. Health insurance is a big one these days, folks, and most folks 65 will start getting on Medicare Part A, Part B, there's a Part C with a Medigap, and then even a Part D. And so really, really important to get your head around that. Medicare typically at 65 years of age, and some folks will also require a supplemental insurance to go along with that Medicare. And depending on your income and what parts of Medicare you have, it usually comes with a deductible and a premium and things of that nature, depending on your situation as well. So there you have it, folks, right there. 5 tips for updating your estate plan. There's many, many more, but from my experience, they're the 5 biggies right there. They're the 5 elephants in the room, we'll call it. There we go, folks. Hopefully this information was helpful. Scroll down, leave a comment, a question. Click the subscribe button and the notification bell, because we'll continue to keep you updated with other important elder law tips and strategies that will help you slay that metaphorical four-headed beast. God bless, folks. Thanks for being here today at elderlawcare.com.